So East African Cables is the latest company to join the list of companies that are facing liquidation. Nakumatt Supermarkets being one of the prominent firms that are on the verge of being liquidated. So what is liquidation and what are the legal grounds that warrant liquidation of a company? To discuss this and other questions, I'm joined by Kagiri Mbugua, an advocate of the High Court of Kenya. A very good evening to you, Kagiri.
Evening, Nina. How are you doing?
Very well. Thank you so much for gracing us with your presence. I'd like us to start off with what exactly is liquidation within the context of insolvency?
Liquidation is just one facet of the practice of insolvency, in that it is a process by which a company's affairs are wound up, or as the word puts it, by saying they're liquidated, you basically mean that you convert the assets of the company to their money's worth with a view to settling the company's liability. Now, liquidation is the ultimate or is the last option when it comes to insolvency practice.
You can give us a bigger picture on insolvency.
Of course. Developing jurisprudence in the country right now, or our legal system right now, in fact, looks at liquidation as a last resort. What the courts emphasize on, or what the judicial system in Kenya right now emphasizes on, is administration.
Okay.
Administration is a process where the law tries to maintain the organization as a going concern long enough for it to be able to repay its debt or to meet its liabilities. It is only until an organization gets to a point where it is proved and presented to the court that even if it is maintained and even if it continues running, it can never be able to recover long enough or perform well enough to be able to meet its liability. Then the option of liquidation comes in. A good example is Nakumatt, because Nakumatt was granted its first orders of administration, I believe, in January of 2018. And since then, now there is an effect that comes with orders of administration being granted. Because once administration is granted by the court, it means that you can't sue the company. And for example, landlords cannot evict that particular company from any premises that they hold. This is meant to give the company a bit of breathing space for it to be able to regroup, maybe come up with a different strategy with a view to bring it back to profitability, so that it can be able now to meet its liabilities. But again, I'll use the case of Nakumatt because it's been the most dominant and most recent case, until it got to a point where they had to let go of all their branches because one of the other retailers bought them out. They had 6 branches left. Naivas came and bought them out. So they no longer have a business to run. And so the last time the matter was in court, I believe was 2 weeks ago, the administrator is now in the process of winding up the organization.
Okay, now that you've mentioned that, what exactly safeguards the shareholders or directors of a company when it comes to when the creditor files a petition to liquidate the company?
Now, ideally what happens is there are certain, once a company is undergoing the process of insolvency, the law tries to prioritize certain creditors first. Remember, even shareholders and directors are creditors to the company because they contribute initial nominal share capital to the organization. So even in the event of liquidation, they're supposed to be paid back the amounts that they contributed into the organization. But the law places a certain emphasis on what we call secured creditors. Secured creditors are, for example, like banks, because they have given credit to the organization, and as a bond for that credit, the company either attached its property, or it's either real estate property or the company's assets, other assets of the company. So those creditors are given priority. Unfortunately, the guys at the lower ebb of the creditors are suppliers, for example, but you of course have to take into consideration government in terms of KRA, which is also now becomes enjoined as a creditor as well. Landlords are also pretty high up because they are very critical to helping the company turn around its operations. But shareholders and directors, in as far as they contributed to the initial capital of the organization, are also looked at as creditors. Unfortunately, what happens is, as is the case, for example, with Nakumatt, when the company is liquidated, And whatever money is realized from that entire process, it is up to, in this case, the administrator, or in the case of a liquidation, a liquidator, to distribute whatever sums are realized, to try and satisfy the debt that is there as best as they possibly. Of course, it cannot meet the entire debt, but they try to distribute it as best as they can to make sure, at least according to that rank and order of priority, the creditors at least get something out of the process.
Okay. Now, in the case of the East Africa cables, what are the implications actually of liquidating a publicly quoted company? Like, it's a listed company.
Well, you know, I was actually listening to the story going on, and I remember there's a time their share price was about 700 shillings for a share. They had to split their shares. Now it's closing at 2 shillings.
Yes.
So that's really sad. But this is a prime example actually as to why the law in Kenya has taken the option of prioritizing administration over liquidation. Because you realize when you're dealing with a publicly listed company, there are so many people who have contributed towards that company. So the judicial system, and we can even, I hope we'll get a chance to review this maybe after the matter is mentioned in court once or twice, will not be quick to liquidate. The first option will be, and I can tell you Robsonaris are going to make applications for administration before court, because that protects the company's assets. That makes sure that no one can go to court without the permission of either the court that grants the orders of administration or the administrator himself. Now, the administrator comes in and is actually at a higher level than the directors, because the directors become what we call, they basically become defunct. And all authority to act on behalf of the company is vested on the administrator. So now he's supposed to figure out how to turn the company around. And that, I can predict, is what is going to happen with this matter as well.
Are there any legal timelines?
Yes. When you talk about liquidation now, at the end, liquidation should take a year, 12 months. That's a period that's stipulated under the law. And if it exceeds the period of 12 months, then the liquidator is supposed to call a general meeting of the company within 3 months and is supposed to present the accounts of the organization. Show this is how much has been realized so far, this is how much of the company's liabilities have been met so far. And if it needs more time, then that is also supposed to be ventilated at that same meeting. The same accounts are also supposed to be lodged with the Register of Companies because the Register of Companies needs to be aware of what is going on with the organization. Administration also will normally be granted for 12 months. Within the 12 months, the administrator is supposed to have called for a creditors meeting where now he presents a strategy and of course presents a proposal to the creditors, which is given before the meeting so that creditors can have a look at it. And creditors will have the opportunity to vote. So either by the directors of the company, or they can appoint proxies to vote on their behalf. A case in point was Uchumi, because when there was a creditors meeting for Uchumi, then guys had to vote. Again, it's become a bit messy in that as well. But Nakumat, for example, both creditors meetings that were held, the proposals were shot down and people were not opting for it. But until that 1 year period ran out, is when now the administrator had to go to court and seek extension of time.
All right. Now, before we round up, under what circumstances, like case in point, Amaco, under what circumstances that the petitioner withdrew the petition?
Now, a petitioner, of course, being someone who has started a claim against an organization, can always withdraw their claim at any time. The headache comes in that once you file the petition to wind up a company or to liquidate a company, to try and defend themselves and to try and safeguard the company, the first thing they do is file for administration. That makes the petition null to some extent. It becomes moot. Because now, if administration orders are granted, it means that the petition cannot proceed. You see? So you've moved on to another realm now, because you wanted to tear down the company. The judicial system wants to maintain the company. And when they weigh it on a balance of probabilities, the reasoning of the court is, look, we can't tear it down for your sake only, whereas if we try and maintain the company, it can actually help so many other creditors, you included, to recover the debt that is owed to you. Yeah. So again, when you go to withdraw the matter, you can only withdraw the matter, for example, hypothetically, once you've been paid or once you've realized your claim against the company.
So that be the case?
Now, once a company is placed under administration, the administrator cannot unilaterally decide to sort you out and
not
leave
sort
the
out
other
the
guy.
rest. Yeah.
You see, so it becomes very difficult to try and withdraw the matter. The individuals who had filed, who had commenced the petition against Nakumat are still a part of it, unfortunately. And it is apparent now that the company is going to be wound up, but they can't pull out as of yet, because they're still hoping that from whatever will be realized from liquidation, they'll get at least a bit to try and settle part of their claims.
All right.
Yeah.
All right. Let's take a very quick break and we shall be back with more news.